For 3 years now, proposed amendments to the Labour Relations Act have drawn sharp criticism from both organised business and labour. At the heart of the intense debate has been the government's intention to regulate labour brokers instead of banning them outright, as demanded by many COSATU unions, especially NUMSA. Business, on the other hand, wants labour brokers to be left as they are. Now, the Labour Relations Amendment Act says labour brokers can only employ a person for a period not exceeding 6 months. And people employed by labour brokers should enjoy the same rights and benefits as those enjoyed by permanent employees doing the same work. Organised business is seeing red.
We believe that the opportunities for temporary employment would be substantially constrained if the bill went through in the form that we had sight of. The estimates in terms of job losses, at a minimum 200,000 jobs would be lost, and those estimates could weigh substantially higher depending on how different sectors went about applying the law.
But Trade Union Federation FEDUSA believes the new law strikes a good balance between the interests of employers and workers.
To ban the process of labour brokers would be totally unconstitutional. And then secondly, to leave it as it is, to allow employers to abuse people is also not right. And that's the reason why FEDUSA believe to regulate the process and to allow for the CCMA, the Labour Court, and the Department of Labour inspectors to be able to enforce those legislation that is now on the book is something that is a step forward.
The power given to the Minister of Labour not only to set minimum wages for vulnerable workers, but to determine wage increases for them is another bone of contention.
This is a further concern we have about the amendments. It affords the Minister and the Director General very broad sweeping powers and again limits the flexibility that we have available in the labour environment. Our collective bargaining system is set up in a manner that affords both workers and employers the opportunity to negotiate towards equitable working conditions and equitable remuneration.
The Department of Labour have always determined minimum wages per sector for domestic workers, for farm workers and so on. I think where the weakness lies was with the enforcement of the legislation, specifically, when you come to farm workers and you come to other vulnerable workers. And I think the balance in the law is quite sufficient. I think what we need to now is to implement those legislation and to ensure that all these abusive practices are dealt with.
The new labour law also seeks to clamp down on violent strikes by holding a trade union liable for violence committed by its members during a strike. However, both organised business and labour believe that will be hard to enforce, as union leaders are quick to distance themselves from such incidents and deny culpability. Mbongeni Mutua, SABC News, Johannesburg.